Good afternoon, everybody. I'm Tiffany Hubbard. I'm very happy to be here, and thank you to the CBIA for inviting me. If everybody just wants to stand up for a second and stretch, please go ahead. I know it's a long slog, and we've been at this all day, and I'm about to drone on for you. So please, I'm not going to be offended. Take a stretch. If you need a bathroom break, we'll catch you up. We'll answer any questions, even if I had already covered it. But again, we'll keep things moving along, but also help you stay awake. Okay. So again, I'm not going to read this for you, but I have a disclaimer slide because I'm a lawyer.
She's still going to talk, okay? You can stand and stretch, but don't leave.
Okay. So disregard my offer to go ahead and head to the bathroom. Okay, so again, I'm going to go through the hiring process. And yes, I'm going to touch upon some Connecticut laws. Again, the laws I'm talking about would be federal and Connecticut. You may have employees in other states. You want to be aware that there are other jurisdictions that may apply. Okay, so this is not an exhaustive 50-state survey. Otherwise, we'd be here until at least midnight. So again, I'm going to go through and cover everything, starting with the unconscious bias in the hiring process. You may have heard of this as implicit bias, and then kind of step through all of the stages of the hiring process, but talk about things from a practical perspective, and also mentioning, some legal issues to consider. And again, I think the checklist that we'll be following, electronically to you, I hope will be a helpful resource for you. And again, it kind of steps through this same process. It is not every single law that could potentially apply. That would not be a checklist. That would just be, the statutes themselves. So again, it's really just a summary. If there's other issues that come up, and you have questions, you can always reach out to your counsel, to a colleague who may know. But again, that's where we're coming from here. But again, I would encourage you, let's try and make this interactive because, again, it's getting later in the day. So if you have questions, ask them. If I can't give you an answer just now, I will connect with you after and give you that advice. And with that, I'm going to give an overview on unconscious bias. So anybody know what bias is? This is not a quiz. Has anybody taken unconscious bias training? So again, this is a judgment that we make regarding a person, group, or thing, and it can be positive or negative. And you can have a conscious bias, meaning you're aware of it, or it could be an unconscious bias, which means it's a judgment that we're making based on assumptions, and we don't even necessarily realize we're making it, or we don't realize we're making it. And so again, I know human nature is, wait a minute, I'm a fair person. I have no bias. I don't have bias. Well, again, we're not going to go into a full bias training here, but just so you know, our brains receive a tremendous amount of information. In fact, it's 11 million pieces of information per second. I'm not sure how they measured that, but I'm going to go with it. I have no basis to challenge that. And so, keeping that in mind, that is a lot of information that you're processing in your brain. And you can only consciously process, they say 40 to 50 bits of information per second. So that means the rest of that information is being filtered by your amygdala, and it's based on your past experiences. And again, there'll be a lot of assumptions there. And it's going to be processed unconsciously using your pre-existing shortcuts. And again, those build up over time. So understanding it, you have to understand that it's coming from assumptions are guiding your unconscious thinking, and the visual cues about gender, race, ethnicity, age, and physique can trigger the fastest and stronger associations in our brains. So has anybody taken the Harvard implicit bias test? Okay, it's an interesting test if you want to go and check that out. It's interesting. I have had samplings that I have gone through, and I'm like, I'm not going to be biased by this. And it's just amazing when you realize your brain is just making these snap judgments. So again, misleading or inaccurate assumptions can filter into our decision-making process, and that's why I wanted to start this with our hiring process. Again, it's based on attitudes or stereotypes that affect our understanding, actions, and decisions, and they can be both positive or negative. And I'm just going to use an example from my personal life, and this is not in the hiring process, but I was about 7 months pregnant with my first child, and my husband and I were out shopping. And we were having a lovely shopping trip. We were checking out, and the woman said to me, "Oh, a surprise baby." And I just thought, whoa, because no, it totally planned. And but again, she didn't mean that to be a negative thing. It was just, she looked at me, she assessed my age, she looked at my belly, assumed I was pregnant, and said, "Surprise baby." I was stunned. My husband's response was, "No, it's a girl." And I thought that was terrific, and I told him, "That was so quick." And he said, "I didn't even notice. I thought she thought we were waiting, and I had assumed it was age." So again, that is not, in the hiring process, although we will talk about, questions not to ask during the hiring process. But that is just one example. So what can you do? You can't say that we're going to make sure we have no unconscious bias in our process. We're just not going to allow that here, right? The science tells us otherwise. It's something that we need to be aware of. Training, education. And I think what the data is showing now is that this is not a one and done, okay? It's not that you go and you attend your diversity training, or like I told you, I went through and watched a series of pictures, and I selected what I thought about each one, so now I'm aware and we're good. This is an ongoing process, and we can't eliminate bias, okay? And that is one thing. I don't know if, has anybody heard of Joan Williams? Joan Williams is a law professor in California. She's part of Work-Life Law and has done decades of research on unconscious bias, and she has a system talking about bias interrupters. And again, looking at it as rather than just talking to people saying you need to do things differently, it's coming up with little tweaks to your business systems to interrupt that bias. And I think one of my favorite examples, and this may be because I majored in music, is the blind auditions for orchestras. And so I don't have the exact numbers off the top of my head, so I'm going to tell you what I remember them to be, and you can email me and let me know I got them wrong. But I think in the 70s, women made up about 6% of orchestra membership, and they introduced blind auditions where a screen was put up, and I think they dampened floors, right, because you didn't want to hear the shoes. And based on that, I think as of 2000, it's over 30% of orchestra members are female. And I think those numbers are very striking, particularly given how long people tend to stay in those positions. Right, when you think about orchestras, people tend to stay in those roles. So again, I put the website on the slide for you if you want to go check out bias interrupters. Just to highlight a few, there are toolkits on that website they offer. But one is decide in advance what factors are important for the job. Okay, that can help you, as opposed to you've now seen your pool of candidates and you're picking based on what you've seen. Give each candidate a separate rating for each factor, then average the ratings to identify the highest ranked candidates. Don't just hire friends of friends unless your networks, your organization, or both are diverse. Consider the candidates from multi-tier schools, not just elite institutions, and make sure to give everyone or no one the doubt. And again, those are just a few of those examples. And so before I talk about the recruiting process, again, you've sat through a lot of sessions today talking about the law. We have anti-discrimination laws that protect individuals in protected classes. I have a slide in here for you that lists all of those in Connecticut. There's a lot of overlap with federal. There are more in Connecticut. But again, those are something to keep in mind. You want to make sure that your hiring processes are not discriminatory. You're not asking information from people that would lead to them providing you information that you don't want to know about them at the early stages of the hiring process. So the recruiting process, where do you begin? And again, I think this starts with your business decisions, right? So this is a mix of business questions and legal questions. So you want to look at what is your business need? Is this just a position that we're going to be filling again? Do we need to take a look at it and tweak that position? Does it need to be something different? Is this really two positions? What is it? What does it look like? And then, again, you want to figure out what are those essential functions of that job? And again, this goes back to the ADA and reasonable accommodations for disability. And so it's very helpful to understand and define what those essential functions are going to be. And so thinking about that, it's not just listing, oh, must lift 50 pounds. Every attorney must lift 50 pounds. It's going to be an essential function, right? That's probably not the case. So you want to make sure that those are tailored to the position, and you want to identify any special requirements. And I can't remember who said it earlier today, but there's over 300 categories of occupations that require licensing in Connecticut. And so again, if it's a job that requires that, that would be something you'd want to be taking into consideration. And how is the position classified? So we just heard about exempt and non-exempt. And so you want to go through and you want to think about that and decide, okay, is this a position that is non-exempt, or does it satisfy one of those white-collar exemptions? And if it does, go through and put down your reasoning for that. And again, I think they made this point earlier too, it's not just about the job description, right? So your piece of paper can say that we meet these criteria, but if what the person's actually performing in the job doesn't match that, that's not going to fly. So that's something to keep in mind to update. But again, that helps you set that out before you do your job posting. So what do you include? And perhaps more importantly, what don't you include in your job postings, right? We only want young men to apply, no one with families. Again, that's pretty extreme, and again, that's in the don'ts. And if anybody just fell asleep, those were don'ts. So you want to make sure you have your equal employment opportunity statement. Again, if you're a federal or state contractor, you want to look at your language. You know, Connecticut state contractors may have a requirement to say equal employment opportunity, affirmative action. You want to make sure that anything that's required to be in those postings contractually is in there and you're following it. And again, you want to put in an overview of the position. What are those essential functions? Any required licenses or certifications? And I think one that's been a pretty hot topic lately, what about COVID-19 vaccination status? Are you going to require it? And so that may be something that you want to put in that posting to let people know that it's going to be required unless there's an exception under the law. So again, going back to Title VII, sincerely held religious beliefs, and under the ADA, disabilities, you have an obligation to engage in reasonable accommodation, just interactive process to determine if there's a reasonable accommodation. So again, you want to put that statement in there if you want that. Another one is remote work, in person. Is it a hybrid? That may be one of the things you want to think about in this early process, and include that in your posting so that people are aware. And again, I think Eric talked about there being over 110,000 job openings in Connecticut. I don't know if he's still here. Did I get that number right? Yes? Okay. I sometimes have a tendency to add some zeros, so I just wanted to make sure. And so, you know, you want to look at that, and is this a position that can be remote? Does it have to be in person? You know, is it somebody on the manufacturing floor? They have to come in, or if it's remote, and is that flexibility going to be something that helps you in more of the hiring crunch? Okay, so again, I gave some examples, but don't include preferences or restrictions based on protected class or language that would deter members of a particular protected class from applying. So again, you know, we want to make sure that that is not being screened out at this stage. So there you go. This is the slide. I'm not going to read this to you, But those are the protected classes under Connecticut law. If anybody thinks I missed one, please email me and let me know. And so then the next thing is to think, where do we advertise this position? Okay, and again, that's not necessarily going to be a one-size-fits-all for the position. You know, you may be looking at having to look to particular industries, and that's going to dictate, you know, other locations where you may post things. But again, on that checklist that Diane mentioned that you'll be receiving, it kind of gives you the job internet boards, company website, intranet, and again, depending on the contractual requirements you may have, you know, if you have affirmative action obligations under a federal contract that's valued at $150,000 or more, you may be looking at the veterans' affirmative action requirements, which requires that those posts be posted simultaneously to specific job boards, in addition to where you may be posting it. So again, this is just touching on a few points. And then, anybody have any questions on the job postings before I move our way into the application?
Okay. Testing? Okay. It doesn't say specifically, but I know we do this, and that is years of experience. Some could conclude that years of experience could be an age discrimination.
Right.
So should we not be putting that on a job posting?
Well,
or is that okay?
I think you should be looking at it, and again, I think that's a really great question, because I had meant to touch upon this. So, you know, has anybody seen postings that say, we're looking for somebody with 3 to 5 years experience? Right? We're looking for somebody with 1 to 6. And again, you know, the minimum experience, that may be necessary. You're looking for somebody who has that experience, but those cap numbers, those maximum numbers for years of experience are problematic. So, you know, that's, maybe you're thinking that this is a job that somebody wouldn't be interested in if they've been in this field for 25 years. This is not a level they're going to want. But that's something to let that person choose, right? So maybe what I love is like, you know what, I didn't like it when my job got challenging, right? I want to go back and do, you know, the second level of customer service where you would normally only have 2 years of experience. And again, that's just an example. So again, that was a really great question, but obviously that's something that could screen people out based on age. And so another thing, so any other questions on the
Right here.
postings?
Hi there.
Hi.
So when we have applications and have candidates come in, there are some requirements for them to meet DOT requirements, and one of them is age.
Right, absolutely. So again, we're going to talk about, you know, the new law in Connecticut that talks about don't ask for age, date of birth, and dates of attendance at an educational institution or years of graduation, right? Is everybody familiar with that one? Okay, good. So that's one, you know, and again, I don't know what it is when we say don't talk about age. I have young children, so I start hearing don't talk about Bruno. We don't talk about Bruno. So if that helps you remember it. But that's right. So one of those exceptions is if it's required by law, right? And so, but typically, and this is, we'll get to this on the application, when you're asking for information and gathering it, do you need the person's age by law? Is it required? Is it a bona fide occupational qualification? Or is it something that you want to know that they're old enough, right? That they're going to be, like they're 18 or older, or that they meet the minimum age requirements for certain, some high-risk work, right? So that's something to keep in mind. But again, if that's a requirement, then you're allowed to ask.
A question from the people online. This has to do with the Crown Act. Is hair a protected class?
I'm sorry, I missed that?
Hairstyles, does that fall in a protected class?
Yes, it does. Yes, so protected hairstyles has been passed. You cannot discriminate based on protected hairstyles. And you're correct, that was not in my list, so thank you. And again, all typos and omissions are mine. So I'm glad, thank you to the person who's attending virtually for raising that. So some of the things that you want to keep in, and I think I glossed over one of the other points I had, which is, you want to put on your application, in addition to your EEO statement, that you also will accommodate disabilities and sincerely held religious beliefs, and provide contact information so the applicant knows who they can get a hold of, right? So people may have some issues during the application process, and providing that information is helpful so that they can actually go through with that process. So one of the other things to include, applicant contact information. I think this came up earlier today in the pending proposed legislation about, it is a discriminatory act to collect the Social Security number on the initial employment application. So, and I don't know, I can't think of a situation off the top of my head where in the initial employment application you would need that. Obviously, there are reasons employers need to collect that, and you may need to collect it on a separate form for certain things, but I think just typically, that's something that you can leave off, right? Especially when we're talking about, data privacy and security. It's one less thing to worry about as to we have Social Securities floating around on those. So again, you want to find out if they have any contractual restrictions. So have they entered into a non-compete that's going to prohibit them or limit what they can do for you? And that's helpful to know so that you know if there's a potential issue there and you don't find yourself in a lawsuit, right? You also want to look at what's their availability to start, and you want to go through those application requirements. Education, again, level, degree only. You don't want to be asking, what years did you attend? Prior work experience. Now, this is another category. How far back do you want to go? Is it forever and ever to the beginning of their job history? Or are you looking for like the last 5 years, 10 years? What is that? And what is it that you need? And again, that may depend on the job. And also looking for what are the skills and qualifications and professional references. You will want to avoid asking questions like, do you have a disability? Another one that can be problematic is, are you able to perform all the essential functions of the job with or without a reasonable accommodation? It's not the same, but again, if you don't know what all the essential functions are, or you don't have a way to know that the applicant's going to know, it's really not a useful question, right? And again, we're going to talk about it a little bit later on regarding the ADA, and that limits what you can ask regarding inquiries about disability and the timing of that, and medical exams. So again, that's not a helpful question. Questions that are likely to elicit information about protected status is a no. And again, things about, do you plan to have a family in the next 5 years? All of those would be bad, and I know those are pretty obvious, but again, that's things that you want to avoid. Okay, another thing that I would suggest including in your application is a statement that the applicant certifies that their answers are true and complete to the best of their knowledge. Again, that's something where you're asking them to provide you their information, verify it, and so then if there's an issue later, you can come back and say, you told me this was true, and now we know that that's false. And again, a related statement to include is a statement to let them know that if you discover that there's false or misleading information or that they've made a material omission, right, that could lead to the rescinding of a conditional offer or termination. That's not saying that you need to have that in the application, but it's a nice notice to put in there. It might have somebody give a second thought as they're filling it out and saying, no, I don't want to, whatever it was that they were going to put down, maybe they've put down the truthful information. And you may want to include a statement that the applicant acknowledges that the application's not an employment contract, because, again, at-will employment is the default. Again, I don't know that an application would kind of convey that it is a relationship, but it can't hurt. So again, we touched upon asking about protected information. I think ban the box came up earlier today, although maybe I'm losing track. But that is the law in Connecticut, so you cannot ask about applicant's criminal records history on an initial application unless it satisfies one of the exceptions. And one of those would be that, it's required by state or federal law, or the applicant is seeking a position that requires a security or fidelity bond or some equivalent bond. So again, those are limited exceptions, but in thinking about that, I just want to step back a little bit on the criminal records history. So unless you're looking at a law that's going to require you to ask at the initial application, you may want to have that further down the road in the hiring process. Because again, depending on the volume of applicants you have in, gathering this information, you don't necessarily need it until you've screened applicants down to the point where you're looking to hire, right? Because then you'll have the time to run these checks, and what that does is it allows you to look back and say, well, no, none of these decisions, this person wasn't excluded from the interview round because of their criminal history. We didn't care. We didn't even ask, right? And so that's a helpful thing. And again, if there's a law that requires it, that's a different story. Okay, and so if you're in a situation where you're required by law to obtain the criminal records history, and you're asking about it on that initial application, you have to still be mindful that Connecticut has a prohibition on requesting erased records. Again, and I have the information on the slide for you as to what those are. And so you don't want to collect that information. You need to put a clear notice in the application that they're not to provide that to you, and you don't want to base a decision on that information. And if the portion of the application that includes criminal records history has to be kept confidential. Another thing we don't talk about, salary history, right? So that's something that you don't request on your application form or in the interview process. And there are exceptions if somebody voluntarily discusses it, but again, that's something that you want to avoid. You can ask about other elements of the compensation, but not the value. So those are the exceptions. Another one, restricted access on social media accounts. So I'm not going to ask if anybody has requested this, but if you were not familiar before, it's important to know that you cannot require an applicant to provide you with access to their personal social media accounts. And I think, again, just as a general consideration when you're talking about collecting that information on protected classes or learning information about people you don't want in that hiring process, you wouldn't want to go there anyway, and you may not want to go and search what you could find publicly on the personal social media accounts. Because again, beware of finding what you didn't want to know. Okay, and so then this brings us to before I go into the selection process for interviews, did anybody have any questions on applications? None? Is everybody awake? Okay, it's either I answered everything or everybody is so tired and they're like, the break is when? So we'll move on here to the selecting the candidate. And again, this is where we're going to talk again about the process and the procedures you have. And again, we can't just say we are not biased. You want to try and control for that. You may want to have several individuals involved in the process and select the applicants who are best qualified for those job requirements. And again, this is where it's helpful if you've laid that out at the beginning before you even post the position of what is it we really want, what is it we're looking for, and who, for candidates. And that's not to say that criteria may not shift, but it grounds it better than putting out the posting and then saying, well, what do we think we want? We've got these people to choose from. So again, I think it can help improve the recruiting and selection process. So, what to ask? Don't ask, is it a surprise baby? You don't want to ask questions that are going to elicit information about somebody's protected class. You don't want to ask about salary history. Probably don't want to ask about criminal records, again, depending on if there's requirements and where that is in the process that you want to begin that. If it's not required by statute, again, I suggest that that just be part of the conditional offer letter, which we'll get to in a bit. And here's a key. So you as HR managers know well what you can and can't ask. But I think the training and educating your managers, supervisors, and others who get involved in the hiring process helps avoid that unexpected pitfall of, oh no, do you know what Tiffany asked somebody today? It's going to be a problem. And again, not only that, but it also can help focus things to get to the questions in the interaction with the candidate that helps you learn who they are better and might help inform your hiring decision. And again, I'm sorry, my countdown clock is gone?
Oh, ignore that.
Okay. I don't want to airplay this. Okay. So I just want to talk about pre-employment tests. So there are some situations where those can be helpful to demonstrate skills or abilities for a job. And so you may want to consider that as a helpful screening tool for applicants. But you want to be also aware that there could be risks that the tests aren't valid or accurate, right? And you also want to be concerned that there could be disparate impact, right? So you think you have a neutral job-related test that you're asking everybody to complete, but it turns out there's a bias in it, and you look at the results, and you're screening out everybody in a particular protected class. So you don't want to do that. So I would think long and hard and assess whether you need it. And that's not to say that there aren't cases that you don't, but you don't want to just throw something together thinking this would be a great idea, let's try this, and then find out if it was any good at filtering. So another one, this is not a new Connecticut law, but polygraphs. Under federal and state law, you can't do a pre-employment polygraph with limited exceptions. And in Connecticut, you're looking at law enforcement. So again, I don't know, I have seen this before, where people are like, well, we think it's a good way to indicate if somebody's honest. I'm like, don't do it. So again, there are some exceptions as to when you might be able to do them, but just as a general rule, that I wouldn't put that on your list of this is my toolkit for screening candidates. So here is another one that's been kind of a hot button question for many, the disclosure of the wage range. Is everybody familiar with the recent change to Connecticut law that requires a disclosure of wage range? Well, good, people are awake. So yes, so I think that has to happen at the earliest time of the applicant's request, or when you're at the time, prior to or at the time that you're making the offer for employment. So I think that some people have had questions and concerns about that with, you know what, we don't want to give this up too soon. What if it's one of our competitors just trying to figure out what our pay scale is? And so I think the Connecticut Department of Labor has FAQs on this, and one is, it references the fact that applicant is not defined under the statute, and says, can we define it, in a way that allows us to protect proprietary and confidential information? And the answer is no. On the FAQs, no, you may not. It's going to be interpreted broadly, and so I think it would be difficult to say that that's going to be confidential information, particularly where I think that was also covered earlier today. You can't tell employees that they can't talk about wages, right? So that it's not confidential. But I don't think that means that if somebody calls up and says, hey, I'm thinking about applying for that position, what's the salary range, right? I think that's not an applicant, right? They filled out the application, then they're an applicant. So that's something to be aware of. And I'm not going to go through them in detail, but wage range has the definition that I've included on the slide. Again, if anybody has a question, I'm happy to answer it.
Tiffany, can you repeat that?
Yes, if I understood it correctly, it was, the second question is, if it's not somebody that you're going to seriously consider for the job, do we need to provide that salary wage range? And so, again, I think the Connecticut Department of Labor is going to interpret this broadly, and if it's somebody you think you're going to screen out, that probably isn't enough. But if it's the CEO of your competitor who's come out and filled out an application, and I think you have reason to believe that that's not actually a serious applicant. But again, this is a new law. I'm sure we will see how this starts to shape up. But in general, those are the time points that you're looking for.
We've got about 10 minutes left. Is okay. We got a question in the middle of the room.
Hi, Tiffany.
Hi.
My question is, if we post it like on Indeed, we can put the range right on there. If it's clearly stated where it's posted, do we have to go over it with them, or as long as it's?
No, you can let them know that it was there. So again, that is actually in the sample hire process checklist that, again, you'll get electronically. One of the things it states in there is talking about providing that if you didn't do so already in the job posting. And so some companies choose to do that. They say, you know what, we're confident with what we're doing. We think that it makes us, more appealable to candidates. We're going to get better applicants that way. So no, it's not that you then have to tell them again. I mean, if it changed, you may want to look at that. And another thing I just want to talk about salaries, you also want to be looking at pay equity, right? And so I didn't mention that when you're talking about the position. And you want to make sure, when you're setting that salary range, is it comparable to other positions? Is it something that's out of line? Does it need to be adjusted? And that's something to keep in mind. And
Any
again,
other questions about any? Okay, got a question over here.
Does it need to be disclosed at the verbal offer, or does it have to be written in the offer letter?
interesting. So, it has to be before or at the time of the offer for compensation. I would think that that would be the oral offer, unless you're following it right up with the written and saying, and the salary range is going to be in there. I don't know that anybody's going to fault you for that, right? But again, I can look into that. I don't know that there's a distinction. I'm sorry, I couldn't hear you.
Yeah, do you think in order to get credit for that, does it have to be in writing?
I think you would want to document it. If you just tell somebody, look, it's the interview process, I want to let you know this is our salary range, you're going to want to document that. Because, and again, I haven't emphasized this enough probably today, which is, you're documenting this process as you go, because you want to make sure that you're able to show that this happened, right? And it's much harder to say, no, I know it was a Tuesday, it was 3 o'clock, they were sitting in my office, and this is what I said, and I wouldn't lie, right? It's much better to say, this is the interview notes, salary range was discussed, range of blah, blah, blah was disclosed. Okay?
Anybody else before she continues on? Okay.
Okay. So final candidate selection, I just blew past my slide there, but again, that's looking at the process. Who is going to be involved in that? Is it going to be multiple individuals? And you have to be aware that, you may have a case where everybody has the same qualifications, right? And so that it's just trying to decide from there, okay, what is it that's going to be, the next thing that we need and for making that decision. And so moving on to the offer letter, unless there's any other questions about salary range or anything else I've talked about. Okay. So what do you include in that offer letter? Well, you want to include the position, the anticipated start date, the rate of pay, hours of employment, wage payment schedule. In addition to that, if you haven't already posted a notice about your policies concerning wages, employee benefits, welfare benefits, again, that was on the slides from the DOL as well. You want to make sure that that's in that note. In the offer letter, you may just enclose a copy of the handbook or some other way of informing them of what those are. You want to include the conditions of the offer. If this is a conditional offer that requires people to go through a background check and other components, you don't want to tell them, congratulations, you're hired. And then on the first day saying, okay, now we're going to do your background check to see if you're going to stay. You want to put in the nature of employment. Is this an at-will employment relationship? You want to make sure that's stated. Because again, it becomes very difficult to say, no, we talked about it. I told you there was no promises. And the applicant says, no, I was promised employment for life. I'm here and I'm staying. And again, that's a little bit on the extreme side. But again, you want to be careful with that language and make sure it's a concise at-will employment statement if that's what you intend. And you also want to think about, do I want an offer letter or am I offering an employment agreement? And is that going to be for a term? Is it going to be termination only for cause? And you want to make sure that those provisions are something you intend. Again, I have seen a contract that appeared to be the accidental evergreen contract with an annual salary increase. So that's one that you have to sit on and notice, okay, I've got 60 days advance notice. So that's something that you want to work on. But again, those I think are unusual. But you also want to avoid the unintended consequence. If you're going to put in there, what the vacation time is in the offer letter, you may want to say that that's the current policy. In accordance with the current policy, it will be X, Y, and Z. You can run the risk of accidentally guaranteeing a bonus you didn't intend. And so again, you may want to reference a bonus plan and that it's subject to those terms. And again, those are things to consider at that stage. So criminal background checks, when are they required? They may be required under federal law. Here I have given you the examples of under Connecticut law when criminal background checks are required. And I want to note that Connecticut law does prohibit applicant credit checks with some exceptions. There are many, but you don't want to just say, you know what, let's just do a credit check on every applicant. You want to make sure, okay, is this a situation where it makes sense? This is for the CFO. Or this is, this situation meets one of those exceptions. Again, they're on the slide, but in the interest of time, I'm going to move on. And so I just want to make sure you're aware of the Fair Credit Reporting Act, right? Now, this is when you're using a third party to do background checks, and that would be criminal background checks, credit checks, consumer reports, investigative consumer reports. You can't just go ahead and do those. You're looking at making sure you have a disclosure to the applicant and obtain their written authorization and provide the summary of rights under the Fair Credit Reporting Act. You want to make sure that those are all included. And I have put in there and noted that it's a standalone document. There have been cases where it's been, it's okay if the disclosure is attached to this and not that. But again, I think the safest thing to do is to just have a separate disclosure and authorization, kind of a 2-page document. Each one's on a page. You're not putting any kind of waiver in there. Any of that kind of language would make that not valid, or subjected to a challenge that it wasn't valid. And there's also notice pre and post adverse action notice requirements. So if you get back information that says, the person has the following felony convictions, you can't just say, never mind, we're done. You have to give them a notice. Again, this is an important step that could be wrong. It could be the wrong person. It wasn't me, Tiffany Hubbard. It was a different Tiffany Hubbard. That information got mixed up.
Tiffany, we've got a question about background checks, and this will probably be the last question, and then we'll have to wrap up.
Okay.
So if you have a conditional job offer and then you do a background check on someone and the background check reveals there are pending criminal charges, the person was not convicted because it's an arrest and you have no idea if they're really guilty. So then can you rescind that, or not rescind, but not make the offer then, I guess, because you weren't comfortable with just what the pending charges were?
I think you'd want to look into that. I mean, if there's a statutory requirement that says, this is a situation where you can't go forward, which I think would be doubtful. But again, you're usually looking at types of convictions. I think that you don't want to just skip to the never mind, right? Because again, this is arrest information, not a conviction. But you want to look at that, the nature of it. How does it relate to the job? If it's totally unrelated, I think I would need to know more specifics about that. Because again, I've received questions about, you know, oh, we're concerned about, you know, this conviction record or these arrests. And when you look at them, you know, they have nothing to do with the job, right? And again, that's a different situation if you're looking at, you know, childcare or situations where, you know, you're running background checks. But if that didn't answer the
Okay,
question
yeah.
completely.
Nope, it did.
Okay.
So unfortunately, I'm afraid I'm gonna have to kick you off the stage. We've run out of time. But thank you very much, everyone. Thank Tiffany.
Thank you.